The broadcast is now starting. All attendees are in listen-only mode.
Good morning everyone, and welcome to today's webinar in which we'll be sharing the results of our work into providing an improved degree of standardization in cloud computing SLAs and contracts. Before I introduce our speakers, I'd like to remind you that the deliverables we've developed and that we'll be talking about today are freely available to download from our website, and we'd welcome continued feedback. A download link will be sent to you via email after the webinar, and we'll also be making the webinar available for viewing online. So again, please let anyone know who would find the content useful. The work we're talking you through this morning has been developed as a result of a broad consultation with both end users and service providers, and we're really looking to find practicable solutions for all stakeholders involved. Today's speakers are Julia Wells from Atos, who will outline some of the issues and problems we set out to address. Then Gianmarco Rinaldi and Deborah Stella from consortium partners Bird and Bird will take us through the main legal deliverables. If you have any questions as we go through the session, please don't feel that you have to wait till the end. Use the question facility online to record them, and then we'll stop at appropriate points as appropriate to take them, or we'll have a Q&A session at the end, depending on what seems most relevant. So without further ado, I'd now like to introduce you to Julia Wells from Atos, who will take us through the introduction to SLALOM and our work. Julia.
Okay, thank you, Rita. So just a very brief introduction, a bit of an overview before we get into the legal webinar, and I pass the word to our colleagues, Gianmarco and Deborah from Bird and Bird. So SLALOM, in a nutshell, it in fact stands for Service Level Agreement, Legal and Open Model. So we have a main objective to create a service level agreement reference model, which has on one side legal model terms and on the other technical model specifications. And with the technical and the legal aspects, we establish a baseline of fair and balanced provisions for cloud SLAs, which can be acceptable both for the cloud service provider and for the adapter. You might say, what is wrong with, well, some SLAs that we have put up some adjectives. Some are more biased to the provider, some are not clear, all certainly complex. To the legal terminology, there's difficulty or impossibility to compare between different providers, and all of this creates some uncertainty and risk for the adopters, especially when they enter into a cloud contract. Now, we have just a couple of examples here of some clauses from actual SLA, from actual contracts. For example, in this contract, the cloud provider is the only party to determine at its sole discretion whether it has not met any of the SLAs specified. So you can have a long contract, and then there are certain clauses which can, at some point, even invalidate the other clauses determining the SLAs which have been set out. This other example, for example, the cloud provider reserves the right to change or discontinue any or all of the SLAs detailed below at any time without notice to the customer. So here as well, you can see that there may be a quite complex series of clauses, checks and balances, but this clause would invalidate any of the other ones and would put the onus on the adopter to understand what is going on or what clauses are valid at the time of their contract. So in this context, SLALOM seeks to close the gap between the cloud service providers who could also base their own SLA, they could incorporate clauses from the SLALOM baseline into their contracts, or use the technical specifications which are being developed, and the cloud adopters who could identify that SLALOM has done a work of detailing clauses which are fair and trustworthy, which could be included in the contracts that they have with their cloud service providers. So here in this work we have counted with the participation of the legal firms. Here, a continuation, we will have speakers from Bird and Bird. SLALOM has interacted and contributed to standardization institutions such as ISO, and we have close ties with the research community within the consortium and through other collaborations that we have. So just an almost final slide, just an overview of who is involved. Atos as coordinator, Bird and Bird, which will carry out this legal seminar. National Technical University of Athens leading the technical work, also with the contributions from the University of Piraeus on the technical and legal side, and the Cloud Industry Forum, which is an industry body which champions the transparency and trust and has organized this webinar here today. And with this, thanking Brita, I will pass the word over to our legal experts and welcome everyone's participation again.
Thank you, Julia. And now, Gianmarco, if you'd like to take us through the first of the legal sections of today's webinar.
Good morning, Gianmarco Rinaldi speaking. We, as a Bird and Bird, we work on the legal part of the work for the SLALOM project. I'm a lawyer and I work in a legal firm, Bird and Bird, which is an international legal practice specialized, amongst others, on internet law and in information technology. And I worked on this project together with my colleague Deborah Stella. From a legal perspective, the purpose in the SLALOM project was creating a set of cloud computing terms and conditions concerning the entire relationship between the provider and the adopters. So our purpose was to imagine a standard model of contract ruling many aspects of this relationship. It's not in cloud computing services, as we know. It's a service which have many different possibility of deployment, as many kind of different offer, and may concern many different industrial sector. So it's not easy to have just one standard model covering all possible all these cases. Our intention, however, was to create a standard which can be a very general model, which could be then also constitute a reference model, which may be then changed or adapted for several different situations. Our model was created also with the help of our colleagues in Germany, UK, France, and Greece, because as we know, cloud computing services may be provided and may be used by and from several different countries. So if you create a model, a standard model, you have to take into account the legislation of many possible different countries. So our effort was to have a model which can be applied and which can be compliant with the law of this jurisdiction. First point is how a standard model of contract may be. So just a few notes on the structure of our cloud standard agreement. The cloud standard agreement is the main document. It's the main document setting out the essential terms and conditions of this contractual relationship between the provider and the adopter. We know that also in the draft of the ISO document about provision of cloud computing services, and also according to our experience in this sector, we know that the main document governing the cloud services is the cloud standard agreement. Then the cloud standard agreement provides and enclosed many other different attachments, such as the attachment 1 concerning the service description, so where which is generally a technical document where the parties described in detail the nature of the services and how the services are provided. Then we have a second attachment concerning the service level agreement. So we know that the service level agreement generally cannot be a document as it's a document provided alone as a sole document, because we cannot have only a service level agreement if we have not a document which is above the service level agreement stating what kind of services has to be provided and the terms and conditions of the provision of these services. So the service level agreement is just normally has to be considered just an attachment of the main cloud service agreement. Then we have an attachment 3, which is an acceptable use policy. This document is the document providing the rules, the rights, and the obligations, especially obligations, I would say, of the users and of the clients while using the cloud computing services. Then we have an attachment 4 about the charge, the consideration for the provision of the services. Attachment 5 about data protection, and my colleague Deborah Stella will illustrate the content of this document. And finally, attachment 6 on security obligations. So this is just to describe the structure of the TSA, so a main document with the essential terms and conditions, and then 6 attachments describing some issues in details relating the services and some specific terms and conditions of these services. But let's see how is the content of a cloud service agreement. A cloud service agreement includes clauses relating to, so service level, we mean the main obligation of the provider to make available the services to the adopter, and then at the same time the obligations of the adopter while using the services. So in our standard we put together these two obligations. On one hand the obligation of the provider to make available the services, on the other hand the obligation of the users, so of the adopters and its users, I mean, so the employees, the contractor, and of the adopter, the obligations they have to respect when they use the services. We will have a clause, a section about the variation of the services, because we know that this is an important issue, because the provider and the parties, I would say, need to know when and how one of the parties, so the provider or the adopter, is entitled to change the services, or when he has not the right to change the services. We then provided a section about the obligations of the adopters. We said before that the adopter has obligations concern, for instance, the obligations under the acceptable use policy. Then a section about charge, the section about service credits. Service credits, as we will see in later is the payment service credit is the main consequence of the default in providing the services according to the service level agreement. A clause about intellectual property, which is a very important issue of the cloud service agreement, and we will see this clause, the content of this clause later. Termination consequence of termination, confidentiality obligations, liability, and other clauses concerning subcontracting, data protection, governing law jurisdiction. So just in this slide you can see just an overview of the contents or the real contents of the cloud service agreement because as we said before, this agreement has the scope to cover all issues and all profiles, I mean, of the contractual relationship between provider and adopters. We underline some clauses, so the 2, 5, 6, 7, and 8, and 9, because we will later we will see in depth the content of these clauses. In our work, you can see that for each of these clauses we made a study. So we provided a general description of this section. We studied what happens about this clause in the market. So what kind of clauses we have in the market about each issue. So this section. We provided which is the provider perspective, and on the other end the adopter's perspective. So you know that in a contract for each clause you could have several different versions, because it depends on the fact that the interest of one party prevails on the interest of the other party. So for each so it's when you make a comment on a clause, you have to take into account which are the interests at stake. And then you can decide if in the negotiation, I mean, you will decide if the interest of one party prevails on the other. We then, for each clause, we provided after having provided all such information, we provided the position proposed by SLALOM. So SLALOM proposed a position which normally is a fair position, so something which is a balanced a provision which balances the interest of one party and on the other party. So we try to give a neutral position which takes into account all the different interests, finding a compromise between the different interests. And then for each clause we provided the wording. So this is one of, we know that there are many, just to give a general comment, there are many projects about cloud computing also under our program Horizon 2020. I think that SLALOM is the only project about cloud computing and terms and conditions, service level agreement, and terms and conditions of cloud computing, which provides a real wording for the contract. So we proposed in our deliverable, we proposed a clear wording, possible wording for a contract between providers and adopters. As we said before, now we are going just to have an overview of some of the content of some clauses. Service, as we said before, service level, service credits, variation of the services, intellectual property, liability, termination and consequence of termination, and data protection. Just start from service level and service credit. We know that when we have, it's a very important part of the contract between the provider and the adopters is the provision of service level, because the parties, the provider and the parties, need to know the metrics, the parameters of the services. at the same time, it's important to know what happens if the service level are not fulfilled. In our standard model, we provided that we had actually many different possibilities. We know that in some countries, under some jurisdiction, under some contractual practice, it's possible to provide also penalties, for instance, or liquidated damages. You can provide also nothing, because we know that in the market we have some cloud computing agreement which, as a consequence of the not fulfillment of the service level agreement, do not provide any consequence, which in our opinion it's something which is could be good for sure, could be very good for the provider, but normally not for the adopters. In our work, we provided that in case of default, in case of not fulfillment, I mean, of the service level agreement, the providers has to pay service credit. So, in other words, we have to make a discount on the payment, on the subsequent payment in charge of the adopter. It's very important in an agreement to provide if the payment of the service credit is the only remedy. For the not fulfillment of the service level agreement. About this point, we did not provide any position. We provided both the clauses because we know that this point is very often negotiated between the parties. So we provided both the possibility. So service credit as only remedy, or service credit as only a partial, payment of the damages connected with the default of the provider. So in this case, the adopter may claim also for additional damages. Another important issue and another important topic of the relationship between the provider and the adopters is the possibility for the parties, generally for the provider, to change the services. There are many possible different. This is important because we know that in cloud computing services, the providers generally want to be free to change the services because they want to have update. They want to update the services. They want to be free to make change, to improve the services. Sometimes also to make a reduction of the services if they want, for instance, to sell separately a part of these services. So their interest is to be very free on this topic. In our agreement, we decided, in our standard model, we decided to provide that the provider will be entitled to change the services, provided such change do not determine in any way a reduction of the functionalities or characteristics of the services as they were offered at the effective date of the agreement. So we decided that for sure the provider can do whatever he wants, but not reduce what he has promised at the beginning of the contract relationship with the adopters. So what the adopters has approved when the adopter executed the contract. So this is the position we decided to have on this point. But we have some exception because we know that in some cases the providers has to be free to change the services. Some exceptions are the improvement due to bugs, defects, or malfunctioning, and in case of new laws, regulations, acts, or orders of the authorities which require change to the services. In these cases, we provided that the provider has this possibility to change the services without limit. However, if the change provoke so cause a reduction of the functionality or characteristics of the services, the parties must agree a fair and proportionate reduction of the due charge. So we found that this could be a fair and balanced position for both the parties. In cloud computing agreement, a very important topic is in the intellectual property right, because in cloud computing agreement we have many different intellectual property rights. We have intellectual IPR from the provider, of the adopter. So the provider, because the provider make available its service, its software, and so we have to consider the intellectual property rights of the provider. Then we have the adopter, the IPR of the adopter, which upload contents on the cloud. We have intellectual property of third parties, because we can have third parties with providing applications on the platform and the provider, and we can have also development activities on the platform. Then we have the intellectual property rights of third parties, only rights on the adopter's data, because the adopters upload contents and data, and such data could be owned, for instance, by third parties. So in an agreement, and in our SLALOM agreement, we provide several different clauses considering all these IPR, and providing indemnities in case of violations, in case of claims concerning IPR. Let's move ahead to liability. We know that this point is very often negotiated between the parties, and this is because the parties want to be the extent of the liability of the provider or of the adopter while using the service, or while providing or while using the service. In our cloud service agreement, the parties may provide a cap, because this is normal in the practice of this kind of agreement. This cap is not applicable to consumers unless specifically negotiated. The cap we provided in our standard that some topic for which the parties cannot apply any limit. For instance, willful misconduct of either party, deceit, theft, fraud, or fraudulent misrepresentation by the party, death or personal injuries, intellectual property obligations, so violations of the intellectual property obligations, breach of confidentiality obligations. So in these cases, we cannot have any limits to the liability of the parties. Then we provided that the service credit may be taken or not taken. So two possible options, taken into account when assessing if the cap has not been met or exceeded. So the parties may choose, depending on their power in the negotiation, which is the best option. Let's move to the consequence of termination of expiration. Then I will leave the floor to Deborah for the data protection issues. The consequence of termination, we know that also this topic is quite important, because the adopter wants to know what happens to its data, to its content, when the contract terminates. We provided that there is a period of time after the termination of the agreement, during which the adopter may retrieve its data from the cloud. So this is the first point. And during this period, obviously, the provider may not delete such data, so as to keep such data and to make available such data for the adopter. The adopter may also request some activities to the provider. So, for instance, a migration to work and to provide services for the migration of the data and the content to another provider. But these kind of activities, so we can call them the migration activities, has to be paid by the adopters. Then we set out that once the retrieval period or the disk transfer or migration period are expired, the provider shall destroy the data. This is important. It's obligation also for data protection, also in accordance, I mean, for reason of compliance with the data protection laws. So I pass the word to Deborah, which shall speak about protection of personal data in cloud computing and in the SLALOM standard model.
Good morning to everyone. The importance of the data protection in the cloud contracts is undoubtedly. In most cases, the services are used to process personal data, and the current European legal scenario demonstrates that the attention on the protection of personal data is becoming more and more important, especially considering the substantial changes that occurred during the past 20 years from the very first directive and the development of the use of digital services. And this presentation comes just at the very right time, in the middle of a significant change and milestone in the way the European Union approach to its legislation comes to protect personal data. The General Data Protection Regulation entered into force this Wednesday, a couple of days ago, and will be applicable, so the companies should comply with its requirements starting from May the 25th of 2018. So 2 years, but it's not so far. Data protection is one of the priorities of the European Union, also in the digital single market, and this is to facilitate, on one side, the necessary sharing of personal data. Without this personal data, it is not possible, and the right protection, it is not possible to come through the sharing of data and to facilitate and favorite the use of digital services. So this is also intended to provide more confidence from the market on the use of cloud computing services. And it is fundamental in the contract also to take into account the need to reach the full transparency, not only in relation to the data subject to which the personal data refers, but also between the in relation to the responsibilities of the parties and who does what. We drafted a clause in the main contract to address the essential element ruling on processing of personal data in the services, and it is essential to have this kind of clause and very detailed instructions on the processing of personal data in a cloud contract, because otherwise the contract might be considered not drafted according to the legislation. The proposed model is built also on the obligation contained in the General Data Protection Regulation, and for the purpose of this document, we consider that the more common scenario, which is the one in which the adopter is actually the controller of the personal data under the services, and the provider is a processor. However, you should check case by case whether this scenario perfectly fits your case or not, because there are some situations in which the adopter is indeed not the controller of the data, but is itself a data processor using the services to process personal data of which its customer is the controller. Let's think about, for instance, to payroll services. If the adopter is a payroll service provider, usually it is not processing the data as data controller, but as a processor. So the model that we propose should be adapted in that case. The main obligation on the processing of personal data should be included in the contract, and this is a specific and very clear requirement of the General Data Protection Regulation. It is no longer possible to rely on very generic wording about data protection, but the regulation requires that the contract include some detailed information about what the processing is, what the purposes are, who are the data subjects, what type of data are processed, and how the provider engage with its processor and subcontractors. The idea of our model is to provide a more general clause in the contract and to rely on an attachment with a very detailed description. We have seen the structure of the master agreement, but how can we practically implement and use it for your services? I would like to give you some tips on how to use it, in your specific case, and I leave the floor to Gianmarco, who will give you some tips on the more contractual issue, and I will close this presentation with some additional tips on the data protection one.
So we have here an example of which I spoke in my first slide about service level agreement, and I said that service level agreement is something which is a part of the cloud service agreement. In this slide, I just want to provide you an example of our clauses, clause about service level. So we provided that the provider shall provide, just try to read and comment it. So the provider shall provide the service in accordance with the service levels under attachment 2 to this cloud service agreement. Where the provider fails to fulfill the service level objectives during the term of the cloud service agreement, section 7 below shall apply. This section I just say that this section 7 is the service credit section, so it's just the consequence, as I said before, just the consequence of this failure to fulfill the service level objectives by the provider. In section 3.3, we provided that the provider has to inform the adopter in case of any anticipated failure to meet any service level objective, and of the steps that the provider will take to prevent the failure from occurring. Why this clause 3.3 is important? Because just to avoid that in case of failure to fulfill the service level objectives, the provider just say that he has some reason, or he has some problems, something which prevented him to respect, so to fulfill the service level agreement. So we provided here that he has to inform previously the adopter, if it's possible to do it, obviously, if he's going not to fulfill the service level agreement. Then we provided a clause 3.4 concerning the obligation for the provider, in charge of the provider, to inform the adopter of the not fulfillment of its failure to fulfill the service level agreement. So this is important because the adopter has to know during the execution of the agreement, has to be continuously informed about the failure of about any failure of the provider in respecting the service level agreement. So this kind of information can be given or with a reporting, so with some periodical reports sent by the provider to the doctor, or in some cases with dashboard to be used by the adopter, by which the doctor can check, can monitor at any time the fulfillment of the service level agreement by the provider. This is the alternative clause you can see in this slide, in case the adopter has this possibility to remotely monitor the ongoing performance of the services. So we know that this possibility, we have this possibility in many cases for cloud services provided in the market. We then have the section 7. We said before that in case the provider fails to fulfill the service level agreement, the remedy, so the immediate consequence, is the obligation to pay service credit. So we provided that if at any time the provider fails to meet any service level objectives, the provider shall pay the adopters the appropriate service credit in accordance with the following sections 7.2 and 7.3. Obviously, this kind of details about the amount of the service credit is not provided, because generally it cannot be provided in the cloud service agreement, but is provided in attachment. This attachment is in our cloud standard is the attachment 2. But in this clause 7.2, we provided that service credits may be recovered by the adopter as a credit against the next invoice, which is may subsequently be due for issue under this agreement. So, as we said before, we just have a discount on the payment, on the subsequent payment of the adopter. We already said before that it's important to know if the service credit is the only remedy. So it's the only remedy, the only consequence of the failure of the provider to fulfill the service level agreement. As I said before, we decided not to have only one position about this point. So we provided both the alternative, because we know that for the parties it's important to negotiate this point and to see the two possible options. So payment of service credit as only remedy, or payment of service credit and then possibility to claim for further damage. So I leave the floor again to Deborah, which will speak about data protection and prepare for service level agreement.
So when you will see our model, you will find that in particular the attachment will require some specific details about how the processing will occur under the services. So it is important for the adopter to start thinking to the contract and to prepare for this contract. It is essential, first of all, that you think what type of data will be processed under the services, because depending on the type of data, there will be different requirements and obligations under the legislation. Let's think about health information. They need to implement some specific security measures, and you should ensure that the contract covers these kind of requirements. You should also list this kind of data in the contract, for instance, under Section 4 of our Attachment 5. And when you have identified the data, you should also you can also understand if these information are all or in part personal data, and if other information are not personal data may be as well protected by confidentiality or secrecy obligations. So it is important to get the full picture. After that, you should categorize them. As we said, there are some data that are more sensible than others and need to be protected and processed in a very specific way. This may also have an impact on the transfer of data. For instance, in some countries, the hosting of data is permitted only in providers who are based in France and cannot move, or on security requirements. After that, it is also necessary to identify the chain of control on the data. As we said before, if the adopter is not the data controller but is a data processor, it should also ensure that before entering into any service agreement, it has the prior consent of its customer and of the controller of the data, and comply with any requirements included in the contract with its customer. And finally, it is really important to be fully transparent to the provider about your data processing. The more the provider has information about what is the scope and the object of the under the processing of data in the contract, the more is possible to reach a full understanding and comply with the legislation. But on the other side, based on our experience, you should also consider to be when you are an adopter to ask for details of the processing and fully understand how the services work. We experience in several cases situations in which the customer essentially did not have any idea of how the services was technically managed and what would have been the consequences on the processing of personal data. So it is important to understand what operations are done, how they are done, and where these operations are carried out. It is essential to understand where the data centers are because of data transfer restriction in the European Union, and also because you should also have a full picture of and control over the data, just in case of there is any specific situation to manage. So, sincerely, be active and not passive when interacting with your provider. Under the General Data Protection Regulation, there are some specific simplifications and benefits in case the adopter, the provider, adhere to code of conduct approved by at the European level, or are certified by providers approved at the EU level. In this case, we think that looking for some provider who has this kind of certification or who adheres to this kind of code of conduct is a preferable requirement. In this case, you, as adopter, you are also facilitated in checking the compliance of your provider in relation to the data protection requirements, because this is what is provided in the General Data Protection Regulation. It is more easy for someone to prove compliance with the regulation and be accountable if they do adhere to this kind of certification or code of conduct that are in any case voluntary. You should not forget to check your documentation with your customers or data subjects to ensure that your documentation and contractual obligations do not conflict with the data processing under the services. So check your notice, your consent, and other obligation under the contracts with the data subject in case there are some restrictions, and manage them before signing the service agreement. And finally, check if there are some prior requirements that you need to comply with your local data protection authority, or in the future with supervisory authorities, because this may be a requirement in the contract, and if you fail to comply with your obligation under the regulation, you might be also in breach of the service agreement. On the other side, the provider's preliminary actions should be more or less in line with those of the adopter. Be clear on what your services offer as a data processing. You should consider that in any case the regulation requires the privacy by design, and even if this is a requirement for the data controller, so the adopter, to ensure that the data are protected since the very beginning of the technology started, then as a provider you cannot forget these requirements, and since you are providing the instrument to process the data, and you should also think about it. Again, understand what are the type of data that the adopter will put under the service, because in some cases there might be some surprises at the end, and the parties should maybe amend the contract or part of the way the services are offered, or specific security measure that you may offer for specific type of data. Or in some other cases, there may be some restriction on the use of some services because of the type of data, so you should also be aware of how the adopter will use the service. Set up also in advance your contractual arrangement with subcontractors. Under the General Data Protection Regulation, you are required to include some very specific wording and obligation in the contract with your subcontractors. You will remain responsible for their processing, and you should also ask for the prior consent of the adopters to use subcontractors. This may be managed in a more easable way, maybe getting the consent for an initial list of subcontractors that you already know that you will use, but it is important to keep it. And consider also getting maybe the certification, and or to adhere to approved code of conduct. There are some codes of conduct that are already in their final stage of drafting, that seems to the code of conduct of the Cloud Select Industry Group, for instance, is one of them. Even if the adherence to the this kind of certification or code of conduct is voluntary, it may be a plus to compete with other providers, because it will give you a more easier way to prove your compliance and to market your services. Then assess the risk, because you have in any case an obligation under the new regulation to notify immediately to the adopter any data breach, not only some of them, but any data breach or security incident that you will detect. So you should set up your data breach security incident response plan. And finally, you should also consider the security details that you should include in the contracts, because these should be documented, and it is no longer possible to include some very generic wording, but you should enter into details. Of course, taking into account any secrecy or very specific security issues. You should provide at least a medium detailed description of these details. We have now concluded our presentation, so if there are some questions about it, we are available to discuss, and I leave the word to Breda.
Thank you, Deborah and Gianmarco. As you can see from the presentation that we've taken you through, a great deal of work has been put into providing a practicable, usable master cloud services agreement. And this process has involved broad consultation with both the adopters, our term for end users, the users of those services, and also providers. So as Gianmarco explained when giving an overview of the model contract itself, we actually took a position having got feedback from both providers and adopters. It's not our intention that this is a one-size-fits-all contract, but that it is a practicable model set of terms that can be a trusted starting point for contracts. Now, as I mentioned at the beginning of the webinar, it is available for download from our website, and I have had a question come in relation to that, and that is, in fact, bear with me for a moment while I get the right, I've had two questions. One is, are there any copyright or other restrictions on using the SLALOM model terms and conditions, including modifying them? And does someone have to mention the source when using them? I don't know which of our speakers would like to take that question. I'll open it to the floor. Julia, Gianmarco?
Yes. Yes, Breda. It's possible to download the SLALOM model terms and conditions in the SLALOM project website. So we will have our website, and everybody can go to the download section and find the deliverable. So also behind, so we have on the technical deliverable and also the legal deliverable, and it's possible to download everything. So you can have a look at this deliverable. So in the deliverable, you will find the complete version of the legal deliverable. For the time being, we have the deliverable 2.2, which is the update of the deliverable 2.1, because as you said before, we received many feedbacks about the deliverable 2.1, and we produced a new deliverable 2.2. Which takes into account all the feedbacks received. So it's possible to download the deliverable 2.2, including the terms and conditions and the commentary, the entire commentary for each clause of the cloud standard agreement.
Yes, just to reinforce that they're open for use, that they are freely downloadable and open for use by the community.
So there is no copyright issues around it. Okay, that's very useful. I've had another question come in asking if there are any organizations which have indicated they would use the SLALOM model terms and conditions in the process of their own contracting. Do we have any initial feedback on that?
Yes, we have had some organizations, I'm not sure right now in terms of publicizing, but and I would have to look back, but we have had some organizations, an SME that is working or some providers that they have found the terms very helpful, and that they were looking to include them as well in their contractual practices. I'm sorry, I didn't. I'd have to look back and see the specific organizations. And we've also had some a collaboration with other projects, finance projects that we're looking into the terms that it complements their own work there as well. There was Sunfish, there was SLA Ready, but specifically it's encouraging to see the SMEs who found the work interesting, and that it's going forward and influencing their own work there.
That's great. Okay, well, I think I don't have any other questions coming in. I'll have one last look. No, so with that, I'll then end the session. I'd like to thank our speakers and obviously all of you for taking time out. As I've said before, we will provide an email link to the deliverables that you can download. We welcome your feedback. And we will make a copy of this webinar available online for you to share with any other stakeholders. So with that, I'll conclude this session and our thanks. Goodbye.
Thank you.
Thank you.